today, and I'm just checking behind the scenes to see if we have our first speaker actually joined in with us. I'm not sure we do yet. Can I just ask you to bear with us for a moment? Let me ask the clerk directly. Ed, has Phil Lonergan joined us, or has he been delayed?
He should be joining. He's in his room at the moment, so I can just go and speak to him if you like.
Yeah, okay, we've got a couple of minutes. It's not quite 1 o'clock. I just wanted to make sure we had the first and second speaker. I can see our second speaker, but not our first. Okay, all right, it's just after 1. Can I first welcome all of you to this, I think it's the 4th or 5th of our ongoing lunchtime CPD series. We're calling them the COVID talks for obvious reasons. But can I also start by saying how wonderful it is to see so many familiar names joining us today. And hello to all of the ones I know, and hello to all of the new friends. Our first speaker is Phil Lonergan. He's a recently joined member of our floor. We're very pleased to welcome him and his specific insolvency expertise. Phil will talk to us briefly about the Virgin Australian administration and give us an update on the proposed sale and the bondholder actions. Immediately after Phil, we have another new member, Blake O'Connor, who's reading on the floor. What a great time to be starting a career as a barrister. Blake will talk to us about tracing in insolvency and the court's approach to intermingled funds in a Ponzi scheme, which I think anecdotally I'm hearing, sadly, we're seeing more of. David Knoll, a very senior member of the floor, will talk about Strata schemes and insolvency. Followed by Frank Tao, another of our new hires, so to speak, who will talk to us about the insolvency cliff edge, how we're about 2 months away from it and what we might expect. As usual, if you want to ask some questions, you are welcome to ask them in person at the end of the session. We will usually have sufficient time. But you can also use the chat function and ask questions to me or to the speaker or to everybody. You get to choose using the chat function, which you'll find in the menu at the bottom of the screen. Again, you come into the screen muted, and I'd ask you to keep yourself on mute unless you're asking a question. And we'll shout at you if you start talking without being on mute. So we'll let you know if we can or can't hear you. Anyway, we expect this will go for until about 2 o'clock, but we hope to have some time for questions immediately before 2. So without anything more from me, can I welcome our first speaker, Phil Lonergan, on the Virgin Australia administration.
Thank you, Michelle. Richard Branson was quoted as saying, if you want to be a millionaire, start as a billionaire and then start an airline. His words were quite prophetic, except for one bit, he's still a billionaire. Nonetheless, airlines, as we know, are a particularly difficult business to be in, particularly at present. Since 1979 in the United States, over 100 airline companies have either gone into Chapter 11 or Chapter 7 insolvency. In fact, Continental Airlines has the dubious honour of having done it twice. COVID-19 clearly has upended the business models of airlines across the world. We're seeing, for example, in Europe, Lufthansa has had to get €9 billion of government aid. We've seen Swiss Air, 1.4 billion Swiss francs in government aid, and we've seen Air France, KLM, to the tune of 7 billion in government loans or loan guarantees from both the French and the Dutch sovereigns. So the question you ask yourself is, why would anyone want to buy an airline today? However, there was a queue of consortiums that stood there and wanted to have a go at buying Virgin Australia. Part of it, which was quoted by the Bain winner, was that the substitutability of trains for planes in what they call the Golden Triangle of Melbourne, Sydney and Brisbane meant that it was unlikely that anything could substitute for the aeroplanes, and they thought going forward that was a great opportunity. Time will tell. The timeline of the deal, or of the Virgin administration process, started in 21 April. Virgin Australia went into administration. There were 39 companies that were part of that administrative process. Funnily enough, the frequent flyer point program managed to slip outside of that insolvency. $6.8 billion was owed to creditors by the 39 company consortium. 10,000 plus credit or persons who were owed money by Virgin. Unfortunately, a lot of them were mum and pop investors who were attracted by the 7.5% yield on the bonds, unsecured notes that Virgin Australia had started issuing since about 2016. 2 billion of the 6.8 billion was unsecured. Of that, Broadpeak and Tor, Broadpeak being a Singapore-based investment management company, and Tor being a Hong Kong-based hedge fund / investment company, held about $300 million of par value of the bonds. We don't know whether they bought them at steep discounts or whether they actually bought them near par value, but they own $300 million worth of it. Broadpeak, and this is set out in his honours judgment on 10 July, had two funds that were invested in these bonds. That was their Master Fund 2 and their Asia Credit Opportunities Fund. We know Broadpeak is a manager of money for Temasek. We know that Temasek is a 20% shareholder in Singapore Airlines. And we know that Singapore Airlines was a 20% odd shareholder in Virgin Australia. So it sort of raised the question early on, and I think that question's still permeating through the present day, of is Singapore Inc. involved here? You know, is Singapore Airlines, Temasek, etc., sitting behind what is going on with the present bondholders' application to the court, and I'll talk about their proposed DOCA shortly, but I think that's the real question, and no one's giving much away in terms of that at present. Tor, who's the Hong Kong-based manager of money that's involved as the second bondholder, they were started by a former managing director of Goldman Sachs, as they all sort of are, who was in their Asian Special Situations Fund. So these guys, you know, it's a fancy word for trading distressed debt, takeovers, and so forth. Then, you know, that's not the sort of background that a private equity person would typically have. The other gentleman who started Tor was the head of fixed income for Citadel in Europe. So again, it would seem unlikely that Tor is the type of entity that would be seeking to take management control and turn around an airline. For example, SEC filings from July last year show that Tor had $1.1 billion in the what they call the Asia Credit Fund, which is the fund that owns the bonds in Virgin Australia. The total firm-wide assets under management is $1.6 billion. Now, that's a lot of money, but it's not that much money when you talk about bond funds. And it's also not that much money when you consider that there's $6.8 billion owed to secured and unsecured creditors when Virgin went into administration. So the point is that there's a degree of skepticism, I think, and we see this a bit in His Honour's judgment, as to what the bondholders are up to. Now, as we know, Deloitte were appointed the administrators. They brought an action into the federal court on the 24th of April, where they sought to do a couple of things like consolidate the single committee of inspectors for the 39 companies within the Virgin Group, alternate methods of service, etc., etc. But interestingly, the 25th of May, the administrators made an application to the court for an extension of time because they didn't or needed more time to figure out the leases on the planes in particular. And they didn't want to, or they were unwilling to take on any personal responsibility for the payments, etc., under the leases, which you can understand. His Honour noted that paragraph 40 of his May judgment that it's $40 million a month in payments for the leases of the aeroplanes. His Honour also said that it's clearly going to be detrimental if the planes get returned to the lessors because the administrators are unwilling to take on the personal liability. The ability then to sell Virgin as a going concern pretty much goes out the window. His Honour also noted that the commercial reality is that there's a lot of planes that are sitting on tarmacs capturing dust around Australia, and it's highly unlikely that there's going to be some better redeployment of the airlines if the lessors got them back. So then 2 July, orders were made in the federal court keeping the sale and implementation deed that was entered into between Bain and the administrators on behalf of Virgin confidential. Now, that SID or sale and implementation deed looks like it was entered into on the 26th of June. The bondholders obviously then brought an action, and this is the one that was reported 10 July, although the reported date of it was the 15th of July, where Justice Middleton dealt with the application by the bondholders to get a look at that sale and implementation deed. So a couple of interesting points that came out of His Honour's judgment there. In particular, at paragraph 14, His Honour said that under section 439C, little A of the Corporations Act, that the second docker, i.e. the one that the bondholders were looking to get in front of creditors, can be put in front of creditors. He repeated that at paragraph 24, where he said there's no doubt that the Broadpeak Tor deal or docker can be put to the creditors. However, he said it's all about the timing. And I'll come back to that because I think that is the skepticism that I referred to earlier. His Honour, at paragraph 14, also said that, and I'll quote this, the administrator may enter into contractual arrangements that could inform the scope of any alternative proposal. Now, that's peculiar because on one hand, he's saying that the bondholders can put forward a docker, to the second meeting of creditors. But at the same time, clearly he's saying that the scope of it can be affected by of the contractual relations that presumably are between the Bain and the administrator acting for Virgin. That's peculiar because Jackman of senior counsel in the court, and this is reported in the papers, said that the administrators had already reached a conclusion that the sale to Bain would go through regardless of the decision at the second meeting of creditors, right? Which is, you know, a pretty forward statement considering that, you know, the court had just said that the bondholders could put forward a second docker. There was also an article in the Australian that said that this sale and implementation deed was entered into on the 26th of June, which is fine. But it's also said that Deloitte and Mr. Strawbridge of Deloitte and Mr. Murphy of Bain had signed the sale and implementation deed, and that meant that the deal would go through by way of the docker being approved, i.e. the Bain docker, or by the sale of assets. And it was on that basis that Bain then committed 125 million, or gave 125 million, injected 125 million into Virgin to keep it going as a going concern. Now, I mean, Bain, you would think, wouldn't do that unless they were near certain that they had the deal secured. So then, you know, His Honour, who's obviously seen this sale and implementation deed, because he gave the confidential orders around it, then sort of gives some hints through his judgment that, that he says at paragraph 26 that the variation of the confidentiality order could jeopardise the orderly process implemented by Deloitte in obviously dealing with the administration. But then he goes on to paragraph 30 and says that the reason relating to the orderly process is because it involves confidential discussions with a range of stakeholders that is necessary to facilitate the successful implementation or completion of the deal, and that creditors, unsecured creditors, won't know until all that's washed out how much they're going to get cents in the dollar from the administration process and effectively payment from Bain. So anyway, it seems like what's going on here is that, at least from the administrator's standpoint, they're doing one of two things or both things, which is they're obviously, I would suggest, screwing down the lessors of the planes. I think it's reasonably well reported that Virgin were paying good money, probably too much money, for the leases on their planes. There's certainly going to be a surplus of planes sitting on tarmacs for a while, maybe for years. So you'd expect that the administrators are putting the squeeze on the lessors, trying to get better deals, bring down the operating cost of the airline going forward as much as they can. It may also be that the Bain consortium are talking to companies like QIC. QIC has made it very clear that they want to step into this deal somehow, and presumably the reason being the Palaszczuk government's desire to keep the headquarters of Virgin in Brisbane. There was a crossing of swords there with the Premier of New South Wales as to that moving out to Badgerys Creek. So, but then you've got the bondholders, and their bid was initially rejected by the administrators as being too contingent. Flaky is probably another word that you might consider. But His Honour noted at paragraph 11 of the judgment that Broadpeak Tor had been working on an alternative docker. That docker involved a debt for equity swap, interim funding for Virgin, and importantly, an expected unsecured creditors return of 70 cents in the dollar. Now that's a big number I think compared to what bondholders or unsecured creditors would get under the Bain transaction. So, they, through Jackman Senior Counsel, they said they needed the access to the Bain deal or to the sale and implementation deed because they needed to develop an alternative DOCA. And that's where His Honour, paragraph 24, quoting back to Mr. Jackman, his own words, where he said it's all about the timing. Now, one suspects that what His Honour is saying is, look, I'm okay if you want to put an alternative DOCA to the second meeting of creditors, but I'm not going to let you look at the hand of your competitor before you do so. Hence, it's all about the timing. And one would think that's fair enough, given that Bain had gone through a process and had been selected, and everyone, when they were going through that process, was was not able to see what the other bidders had put together as their offer. So now to allow the bondholders a second bite of the cherry is one thing, but to give them a second bite of the cherry and also show them the hand of the guy who is the front runner is a bit unfair. So I think that's really where His Honour was coming out. And at paragraph 25, he makes that point that all creditors will get the details of the SID, the sale implementation deed, in the administrator's report, which is obviously issued pursuant to the insolvency rules. So I coming into sort of preparing for this on the weekend, my personal view was, well, it's unlikely that Broadpeak Tor are going to do much more than be, putting pressure on Bain to just get more money for the unsecured creditors. And this is, an aggressive ploy to do so. But, activist investors, are not unknown to be quite active and aggressive in the pursuit of return on money deployed. However, then Monday, this week, they have come out and they have submitted a tentative DOCA to the administrators to consider. And at least one commentator has said that this is just a further bid on the part of the bondholders to put up pressure for Bain to pay more money out under the deal. Now, that may be true, we don't know, but the bondholders, to be fair, have also come out and are on the record as saying that they have the funds and they have the ability to implement the deal. So that, at least I view that as quite a forthright assertion of capacity. And again, that takes me back to where we were before about the Singapore Inc. Consortium. And it may be that actually sitting behind Broadpeak, probably less Tor, but Broadpeak, is the Singapore Airlines or a related consortium that are going to step up and be more aggressive in this. So the bottom line of it all is that there'll be two DOCAs by the look of it that go to creditors on the 26th of August. The administrators will have to have their report out a number of days, I think 5+ days before that. I believe Bain have to have their DOCA to the administrator around the 12th of August. It seems that Broadpeak have already got at least a tentative DOCA in front of the administrators. So I guess the bottom line of it all is watch this space. It is not over yet.
Thank you very much, Phil. We'll move quickly to our next speaker, who is Blake O'Connor, tracing in Insolvency the court's approach to intermingled funds in a Ponzi scheme. Over to you, Blake.
Great, thanks Michelle, and thanks Phil, and thank you to each and every one of you for attending. We've got a great turnout, so that's fantastic. I wanted to talk to you about tracing. I recently had occasion to look at this subject. It's one of those areas of equity that doesn't arise with any great frequency, and it's a topic that university students usually hope doesn't come up on an examination. However, in the insolvency space, it is a very valuable tool to use when seeking to maximize returns, and especially when seeking to track down missing funds. In particular, tracing is used where there's been some suspected foul play, theft, or unlawful dealing. Unfortunately, that is occurring more and more, so it's a very useful tool. In the time allotted, I propose to outline first what exactly tracing is and how it can be used, and second, to provide just one example of tracing in the context of fraud to demonstrate what happens when you have intermingled funds, that is, funds of different persons going into the same pool in which you're trying to trace. So tracing is one of those terms in equity that gets confused. Precision of language when discussing tracing is very important. It reminds me of some of those equitable principles that are called presumptions when in fact they're not. And you get into all sorts of judicial commentary on this kind of language. Tracing is not a remedy and it is not a right. Tracing is very simply a tool of evidence. It is used by a party to demonstrate what happened to his or her or its property. This tool of evidence called tracing then gives rise to proprietary remedies. For example, an equitable charge, an order for the return of certain property, or the imposition of a constructive or resulting trust. Justice Campbell, in a decision of Re French Caledonia Travel, put it like this: tracing is the means by which the court identifies what property of the trust the trustee still retains for the purpose of the court crafting orders which aim to make the trustee perform this obligation. So if I pause and give you a topical example, let's say that a solicitor misappropriates client funds and uses those funds to buy a house. The plaintiff who seeks a return of the funds, or the insolvency practitioner appointed to the law practice, could obviously seek an order that the house is held on trust for the plaintiff or the victim. The evidentiary tool of tracing would be used to demonstrate how the money flowed from the solicitor's trust account over into the person, then over into the real property. This exercise can be performed by putting on a tracing affidavit. For complicated cases, forensic accountant experts, some of whom are on this Zoom chat, can be retained to perform that exercise. It can be quite a difficult thing to do. You need to have a proprietary interest in property to demonstrate a tracing evidentiary position, and the rules of trust apply in that respect. To take the thieving example, if a person loses funds by way of a theft, then they have a proprietary interest in the stolen money, of course. If the thief converts the property into other property or gives that money to a third party, then the person would still have a proprietary interest in the funds because it would be held on trust for the innocent victim on a resulting or constructive trust, subject to certain rules around notice that I won't go into. This is a well-established principle. It's called a Black and S. Friedman Trust, arising from a High Court case in 1910 of the same name. It is that immediately upon a third party receiving stolen money, a resulting or constructive trust arises in favour of the beneficial owner. The decided cases that have dealt with those sorts of trusts arise quite often. There's a real issue, however, that arises when we're looking to use this tracing tool of evidence, and that is where you have multiple amounts all being paid into the same account. What happens then? In other words, how do you trace those monies? Well, the courts have developed 3 rules to deal with this issue. The first is the rule in Clayton's case, the second is the pari passu rule, and the third is the lowest intermediate balance rule. A real-life example will help identify the problem, as it was very recently considered by the New South Wales Court of Appeal in June of this year in a long judgment in a case called Karen and Jahani, and the medium neutral for that is 2020 NSW CA 117. This is an interesting case. It is a case that comes out of a very long saga called the Courtenay House Trading Company and its associated actors and investors. Courtenay House, it's got quite a regal name, was promoted as an investment venture which accepted funds from investors for the ostensible purpose of investment in foreign exchange trading from about 2010. I say the ostensible purpose because the Court of Appeal found that Courtenay House had not actually engaged in very much foreign exchange trading at all, but it was using the funds from later investors to pay out earlier investors. So this is the traditional Ponzi style behavior that we've all become accustomed to. Over the life of the Ponzi scheme, between $213 million and $248 million of funds were deposited by investors into the company's bank accounts. So it's a scheme of significant import. Contrary to the marketing of the companies, little foreign exchange trading was done, as I described earlier. Once ASIC caught wind of this scheme in 2017, they urgently obtained ex parte freezing orders and restrained the company from dealing in its assets. At the time liquidators were appointed, $21 million was in a Westpac bank account. So we've got $250 million paid in, $21 million left. Some people are going to be out of pocket, obviously. There's going to be some upset investors. So this is where the evidentiary tool of tracing comes into play. We have to work out, well, who has an entitlement to those funds? Do some investors have a greater right than others? Or is it a general first in, first out principle? The Court of Appeal held that there were three rules. Again, the pari passu rule, the lowest intermediate balance rule, and the rule in Clayton's case. The rule in Clayton's case is the first in, first out principle. The pari passu rule merely states that funds should be distributed ratably by reference to the amount of individual investments proportionate to the remaining funds. And third is the lowest intermediate balance rule, and that is a depositor's share is reduced ratably wherever there is any withdrawal from the fund. So there's this sort of constant adjustment under that rule. And President Bell's judgment is long and detailed and is a really good exposition on each of these three rules and the pros and cons of each. And His Honour is keen to emphasise that the application of one rule depends upon, of course, the particular facts and circumstances of a case. But in this case, the lowest intermediate balance rule was preferred. And His Honour went on to say that it provides the fairest, most equitable and principled outcome for the allocation of limited funds between investors. Application of this rule permits the tracing of surviving proprietary interests where a party can identify through tracing his or her equitable property. So this decision confirms that of the three available approaches, the lowest intermediate balance rule is preferred. So on the subject of tracing, I will just wrap up by reminding you, firstly, precision of language. It is a tool of evidence and not a remedy or a right. Secondly, it can be performed where a person has a proprietary interest in the property, giving rise to a remedy such as a trust. And where a situation of intermingled funds occurs, just have regard to the three rules and which is most appropriate in the circumstances. But thank you very much. Back over to you, Michelle.
Thank you very much. Very interesting. You all know, of course, that this is a topic which is of significant intellectual and judicial interest to Justice Edelman on the High Court, among many others. But Justice Edelman in particular seems to have an abiding interest in the topic, and he's written widely on it. Can I recommend volume 16 of the QUT, Queensland University of Technology, I think their law review, where His Honour Justice Edelman has written an article called Understanding Tracing, which is some of the clearest language I've ever read and the most useful examples coming from a very renowned scholastic mind. Also touching on the recent schism between Australia and the UK coming out of the House of Lords in the Bank of Cyprus case. There's a note on that at the end of the paper. Thank you, Blake. That was terrific. Our next speaker is David Knoll AM on strata schemes and insolvency. Over to you, David.
Thank you, Michelle. Many of you will know that the strata legislation provides that the Corporations Act doesn't apply to strata corporations. So how do they become insolvent? Well, it's actually quite a conundrum, because insolvency can affect the strata corporation when it has massive liabilities to fund repairs and it can't collect enough money in levy contributions from owners to meet the liabilities. The owner's corporation's obligation is not a best efforts one, it's a strict liability under Section 106 of the Strata Schemes Management Act. And worse yet, there is no procedure to wind up an owner's corporation. There is a procedure to appoint a strata managing agent under Section 237 of the Act, but that agent will merely perform the functions of the owner's corporation if it's become dysfunctional and try to collect the levies. The only source of funds that a strata corporation has is the levies. Now, you can pursue a lot owner for unpaid contributions the same way you would pursue any other debtor. And at present, as most people will realise, during the COVID-19 restrictions, one can't bankrupt a lot owner for not paying their levies. Owners' corporations have one weapon, however, that ordinary creditors do not have. Under Section 86 of the Strata Schemes Management Act, the tribunal, or indeed a court now, can make an order that contributions be paid together with interest on the contributions and the reasonable expenses of the owner's corporation incurred in recovering them. Now, the point about that order is not that it's a means of recovering interest and expenses as long as you've given 21 days notice. The point of it is that you can exercise this right even after you've got your first judgment for the contributions and even after you've issued your bankruptcy notice, so that you can get a second judgment upon which to found a creditor's petition. So it's a very useful tool under Section 86. The difficulty, of course, is always that your bankruptcy notice could become stale and you have to keep an eye on your time limits, because even the very efficient registrars at the local court may not get you on in under 6 months. In March 2017, this is old news but is often forgotten, the Australian Financial Security Authority provided that post-judgment costs can't be incorporated into a creditor's petition. And they did that to ensure that the petition would only rest on judgments, but they did not address fully the power of Section 86. And that is that you can have more than one judgment that can become the subject of a creditor's petition. If you want to have a look at the authority for what costs you can recover, it is a Court of Appeal decision called Owners of Strata Plan 36131 and Demetriou, which is at 2009 74 of the New South Wales Law Report 370. And that was a case in which an owners corporation sought to recover levies from Mrs. Demetriou. Before they had even commenced, she had sued in the tribunal to get out of paying her levies, and the local court proceedings were stayed, and the tribunal then dismissed her application. Back to the local court went the owners corporation, and now also claimed the tribunal costs as a debt in the local court action. They succeeded before the magistrate. Mrs. Demetriou then appealed to the Supreme Court, and Associate Justice Malpass overruled the magistrate, and the Court of Appeal then overruled Justice Malpass. Justice Handley had no difficulty in ordering that an owners corporation could recover its reasonable costs in each of the proceedings, even if there wasn't a cost order, in much the same way as a mortgagee can recover contractual rights to costs that are cumulative of cost orders made by a court. And if you want to find the origin of that rule, it'll be in the paper that will go up on our site and LinkedIn. But it's a case called Gomba Holdings in the English Chancery Division in 1993. In case you're wondering how much was at stake originally with Mrs. Demetriou, it was the sum of $1,214.93, and it became the subject of 5 hearings. But one of the most important tidbits from the decision is a piece of obiter from Justice Hodgman, which you'll find at paragraph 49, that at the hearing, an owners corporation can reserve liberty to apply subsequently in the same proceedings to claim expenses incurred in enforcing a judgment. That liberty is far too often not exercised by solicitors who collect judgments for owners' corporations, and it is important to maintain that liberty so that when you come to file your creditor's petition, you can pick up all of your costs. The bigger problem is this: what if it's not one owner who can't pay, but most of the owners who can't pay, because the amount that is levied comes to millions of dollars? The High Court in the Brookfield and Multiplex case concerning Strata Plan 61288 back in 2014, and I'll put the site up as well, but it's 2014 254 Commonwealth Law Reports 185, decided that a builder does not own a duty of care to an owner's corporation, or indeed lot owners, in a claim for pure economic loss for latent defects in the common property. The High Court drew a distinction between someone who supplies something that's defective and someone who supplies something that, because of its defect, causes loss or damage to something else. The builder was expecting to lose in that case based on holdings in an earlier decision of Brian and Maloney, but succeeded. And the judgment of Justices Hayne and Kiefel held that the owner's corporation had relied on the builder to do its job properly, but reliance was not enough, and the owner's corporation did not demonstrate that it had a special vulnerability. Well, that problem's gotten bigger. You'll know of the Opal Tower case. It was a 392-unit building that was evacuated on Christmas Eve 2018. There were cracking sounds in the tower. There was a government investigation. Poor assembly was found of the prefabricated panels on several floors. Non-compliant construction and structural design of the fabricated concrete beams caused the cracks, and yet an occupation certificate had been issued. Not all the residents have been able to move back in. They all want compensation for the difference between the actual pre-defect value and the current market value. And most of them fear that the reputation of the building is now so bad that they couldn't sell their units at any price. And what bank will lend to a buyer proposing to buy a unit at Opal Tower? So they've sued the Sydney Olympic Park Authority, known as SOPA, which owns the land on which the tower sits. And SOPA had subcontracted to a company called Australia Avenue Developments the design task, and Icon Co, a subsidiary of a Japanese company, to do the construction work. And they put out some action after they had 12 independent experts finding 500 separate common property defects. So what did the owners have to pay? A $1.1 million special insurance premium. Those proceedings have been on foot for just over a year, and they are just about to finish the pleading stage with multiple claims and cross-claims. Opal Tower is not unique. There's 132 units at Mascot Towers where the owners are now homeless since the 14th of June 2019. They have facing a $15 million bill in damages, and they have sued the neighbouring building's developer, claiming that when that building went up, it caused the damage to their building. Assuming for a moment that they could have distinguished Brookfield, they would have great difficulty in pursuing the builders, who of course are not on the scene anymore. You might wonder, what about home building insurance? If your building is 4 stories or more, you don't have it. And there's a 6-year statutory warranty period for major defects and 2 years for minor defects. In most cases, that won't help. And even if it does, it only operates if the builder has gone under, and it doesn't cover your lost capital value in the apartment, among other various costs that the home building insurance doesn't cover. There are now 130 buildings identified in inner Sydney which have been told to replace flammable cladding, and have been told that the way in which the cladding was inserted will require structural work. So what has the government done? And this is the news that is fresh. The government passed the Design and Building Practitioners Act 2020, and it was assented to on the 10th of June of this year. The title is innocuous. You'd think it's only about tightening up requirements for design and documentation for buildings, but it goes much further. Section 33 empowers the government to issue developers building work rectification orders. That can relate to works that were done up to 10 years before the Act was passed. The government can also now intervene to stop occupation certificates being issued. But the most important part, I would suggest, of the Act for practitioners is that it now imposes on builders, designers, product manufacturers and suppliers duties that they cannot contract out of, and the duty operates retrospectively to cover losses that became apparent up to 10 years ago. The critical parts of the Act you should be aware of, and again, I'll put them up on our site, are Section 37, which extends the duty of care to be a duty to avoid economic loss caused by defects, and it is a duty that is owed to every subsequent owner of the land. Section 38 identifies that an owner's corporation can sue, even if it wasn't the owner when the work was carried out, and that usually will be the case. Section 41 in turn provides that a claim under these statutory provisions, while subject to the Civil Liability Act, is not subject to any quantum cap at all, and not separated from, it can be sued on in addition to common law rights. You have to dig a little to find the retrospectivity. It's in Schedule 1 to the Act in Clause 5, and it's explicit that it extends to construction work carried out before the commencement of Section 37, and it goes, as I said, back 10 years from 10 June 2020, so back to 10 June 2010. So the government has provided some potential relief, but if your defects predate 20 June 2010, you may well have an insolvent owners corporation insolvent because none of the lots can possibly sell their lots. These are difficult times with difficult remedies, giving rise to a lot of litigation. And regrettably, to this day, there is no insolvency procedure for strata corporations. Thank you, Michelle.
Thank you, David. And our final speaker is Frank Tao, who will bring us up to date on insolvency approaching the cliff that we're also worried about. Over to you, Frank.
Thank you, Michelle. When I settled on this topic a couple of weeks ago, the number of new COVID cases in Victoria were in their teens, and no one amongst us has probably ever heard of the Crossroads Hotel. Fair to say things have moved on pretty quickly, and what we're facing now, it seems, from recent announcements by the federal government, is the potential for another few rounds of government intervention economically and perhaps later legislatively to support the Australian economy. Most recently, people have heard that Treasurer Josh Frydenberg has announced the job seeker extension, which would lengthen the payment for part-time and full-time employees till early next year. Now, the context in which I want to speak briefly to the audience is in relation to the current measures that the Treasurer has provided to businesses, individuals, and that is relief from enforcement of debts by extending the period for complying with a statutory demand or a bankruptcy notice to 6 months. The safe harbour provisions under the insolvent trading regime, and also a temporary relaxation of the continuing disclosure obligations. Now, those continuing disclosure obligations are being relaxed until November. The other measures were due to expire on 25 or 26 September 2020. And it will be fair to say that it is not an exaggeration to expect that there are many creditors who are probably waiting for that deadline to expire in 2 months and a few days' time, and to send out their statutory demands for debts they've been waiting to enforce. Whether that deadline is lifted or whether it's extended, one needs to wait and see. But I think it is fair to extrapolate from the latest round of job seeker extension payments that the government has announced, that the federal government is keen on ensuring that this proverbial cliff edge doesn't result, at least not as hard hitting as one may have feared. And I think at this stage it's useful to look at some of the statistics that are available in recent months to consider the extent to which the government's measures to date have impacted on corporate insolvencies. So in April and May, there were, in terms of liquidations, respectively, 410 and 429. Now, compared to the same time a year ago, that's about 50% less month to month. And compared to January 2020, which is generally the quietest month of the calendar year for liquidations, we saw 397 liquidations. And in February and March, we were looking at in the high 600s for each month in terms of liquidations. So it is fair to say that the measures to date have had a material impact on staving off companies who may have considered and putting themselves into an external administration. I guess the question is, how does one go about making a prophetic judgment or prophetic call as to what may happen next and whether and how close we are to the cliff edge? I provide a few indicators that I think will be useful for us as litigators and insolvency practitioners to get a sense on when the curve may be changing. Now, one of the most useful things, I think, is actually to look at what the Deputy Commissioner of Taxation is doing in terms of the steps it is taking to wind up companies. Now, this can be done, I think, anecdotally from speaking with our peers and also from looking at the activity in the courts. Now, anecdotally, from my personal experience on matters, the DCT have not been as, shall I say, vigorous in relation to proceeding to judgment in respect of unpaid tax. One example I give is a taxpayer which was subject of a freezing order for running account balances in quite a significant sum, and the ATO has not to date, many months down the track, proceeded to judgment, despite it seemingly being able to do so by seeking summary judgment. Now, one may speculate or conclude that one reason for that slowness by the Deputy Commissioner of Taxation is the practical utility of obtaining judgment when he can't then take steps to enforce that through a statutory demand and winding up proceedings. So that may give some sense as to the current state of thinking of the ATO, and if that state of mind changes, that can provide an indication of perhaps some greater propensity to take formal insolvency action, or at least to move towards that. The second indicator I would suggest that practitioners have regard to is actually the court list, the very humble court list. Now, I had a look at the last few weeks, and just by way of example, the length of the number of matters in Justice Hammerschlag's commercial list last Friday was 47. And the number of matters in Justice Black's corporations list this Monday was 22. Now, those numbers are drastically lower than in the case of the corpse list, what the number of matters were at the start of the year. And in the commercial list, significantly lower, for those whom I recall, than the numbers that would appear in every Friday in Justice Hammerschlag's list in 2008, 2009, after the global financial crisis had commenced. Now, I think those two lists, plus the Registrar's Corporations lists, where most of the winding up petitions are presented in the first instance in both the Federal Court and the Supreme Court, provide a very useful objective indicator of what activity we may be seeing come September. And if you want to get further clarity on that, I think it's a simple matter of just seeing which matters are new, which matters start with a 2020 prefix in terms of the matter number. And I think that provides a very helpful and objective indicator of the busyness of the corporations courts and also in the commercial list as to how much litigation will have been commenced since COVID to what I would imagine to be commercial debt or to enforce or incorporation matters, including, of course, applications to set aside statutory demands. Now, other indicators that I think will be helpful is in the commercial context. People recall that at the start of the pandemic in about February and March, the major banks announced various measures of relief for business and mortgagors. And the principal form of relief was in terms of amortization of payments and basically capitalizing those amounts due for a 3 or 6 month period. Now, those repayment holidays, so to speak, will once again be ending very shortly. And it will be interesting to see what announcements the banks make in terms of whether they extend that relief or whether they call it a day. Now, bear in mind that the banks offer or commercial or what I'll call as financial accommodation for this month to both SME clients and also residential clients or retail clients was on the back of the RBA's offer to provide billions of dollars to the Australian ADIs at cost of funding well below the market rate. And it was in effect to pump money into the banks and to stimulate the economy. That was, I understand, from RBA's announcement earlier this year for about a 3-year period. So it'll be interesting to see whether the banks take full advantage of that accommodation from the central bank, or whether they decide to take a more stringent view come September. Another aspect to probably look at is what the ASIC's approach is. Now, a few months ago when the COVID crisis came about, what ASIC announced was that until 30 September this year, it would prioritise its focus on matters where there's risk of significant consumer harm, serious breaches of law, or where there are matters of market integrity or matters which are time critical. Now, come September, when the government measures are currently due to expire, I think it'd be useful to look to ASIC to see what its position is and whether it will continue with its current prioritisation or whether it will revise its triaging of matters. And that, I think, will give a good indicator as to what the regulatory appetite is in its interaction with the insolvency space. So in the time available, I thought those may be helpful indicators for our fellow practitioners to get ahead of the curve and perhaps maybe, be able to assess when the cliff edge may arrive. Thank you.
Thank you very much, Frank. Well, that's the end of our presentations for the day. You may have noticed that Frank has put up in the chat a link to the Court of Appeal's decision in Caron and Seidlitz. He's also put a link to the Edelman J article that I mentioned, and he's put a link to the High Court in Multiplex and to Brookfield, just in case you're interested in following any of that along. Keep in mind too that our floor website has some of these sessions as recordings, and you are welcome to come back and have a look at that. It'll also give you the contact details for all of us if any of you want to ask any of us a particular question, or indeed if you'd like to brief any of us, which we certainly encourage. We do have a tiny bit of time if there are any questions. I haven't got any through, I've got some lovely comments through the chat, but no questions. Does anyone want to take themselves off mute and ask a question? No, everyone's shy. Terrific. Do keep in mind too that we run these regularly every 3 or 4 weeks, but we are also keen to know what you would like us to talk about. So if you have any great ideas or something that you'd like us to have a think about and is suitable for a CPD type presentation, do please let us know. Speak to our clerk, speak to any of us, send us an email. We're available in lots of different ways. Thank you again for joining us. I hope to see you next time. Bye, everybody.